Hello everyone, and welcome to the August 2025 edition of My PIP Monthly. This month's presentation is brought to you by Senior Partner Mark Masters and myself, Executive Partner Caitlin Milroy. Today's topics first include our usual most recent case law update. The first case we will discuss is the recent unpublished opinion per curiam of the Court of Appeals that was issued on July 10, 2025 of Asia Davis versus Timothy Gary English, an Allstate Insurance Company, and VHS of Michigan, Inc., doing business as Detroit Medical Center. The second case law update is on the unpublished per curiam opinion of the Court of Appeals that was issued on July 23, 2025 of Bronson Health Care Group, Inc., and Alfredo Z. Estrada versus Progressive Michigan Insurance Company. Lastly, we will focus on our discussion on the trending topic in PIP litigation of the notice requirement of injuries and MCL 500.3145. I will first give you a brief overview of the topic and statute. Second, we will discuss the case of Hoover Physical Therapy LLC and Medical Direct Transportation LLC versus Amerisure Insurance Company and Berry 365 Day Transportation LLC et al., which has issued two applicable unpublished opinions per curiam of the Court of Appeals that were both issued on July 22, 2025. The first case we are going to discuss is the unpublished opinion per curiam of the Court of Appeals issued on July 10, 2025 of Asia Davis versus Timothy Gary English, an Allstate Insurance Company, and VHS of Michigan, Inc., doing business as Detroit Medical Center. This case discusses the equitable apportionment of PIP benefits pursuant to MCL 500.3112 and appropriate payee designation for same. Also, this opinion contains further analysis of the case of Michigan Head and Spine Institute PC and McLaren McComb and Daniel Crane and Regents of the University of Michigan versus Nationwide Mutual Fire Insurance Company, which is the recent unpublished per curiam opinion of the Court of Appeals that was issued on May 15, 2025. As you know, we previously discussed this case in great detail in the My PIP Monthly back in June. Plaintiff was involved in a serious motor vehicle accident in 2021 and received medical care at Detroit Medical Center for several weeks as a result. Plaintiff's claim was assigned by the MAIPF to Allstate. Plaintiff ended up suing Allstate for benefits in the alleged at-fault driver, while VHS/DMC sued Allstate in a provider action. Both cases were eventually consolidated. DMC's bill totaled over $730,000 and included a Medicaid lien of over $111,000. Given that this is an assigned claim, we know only $250,000 to be available for allowable expenses. For that reason, Allstate filed motions for declaratory relief and disbursement to designate the payees of the $250,000 available for allowable expenses and to equitably apportion those available funds. To resolve these disputes, the trial court conducted 2 hearings and issued at least 4 separate orders. In all, the trial court's orders directed that nearly the entire $250,000 cap available must be dispersed to the provider, DMC. Further, DMC was ordered to reimburse the Medicaid lien only $300. Plaintiff then appealed and argued that the trial court erred in failing to designate the appropriate payees to receive PIP benefits and by failing to make an equitable apportionment contemplated by MCL 500.3112 of the limited benefits available for allowable expenses among those entitled to benefits, including plaintiff. First, the Court of Appeals found that the trial court erred by dictating that the 6-figure Medicaid lien was part of plaintiff's third-party claim. If anything, the court found that the trial court should have continued to recognize that the Medicaid lien should have been elevated in priority for payment. Second, the court found that the process of equitable apportionment under MCL 500.3112 was pretermitted by the trial court's reliance on the first-in, first-out method for allocating the $250,000 in benefits that were available. The court notes that this approach contravened the court's recent conclusion in the Michigan Head and Spine Institute PC case, which is that the statutory language affords significant discretion to trial courts in that regard. In that case, The court held that MCL 500.3112 certainly authorizes the trial court to apportion the available PIP benefits, but MCL 500.3142 does not require payment on a first-in, first-out basis like the trial court here said. Given the aforementioned, the court vacated the trial court's orders and remanded for further consideration under the principles enunciated in the case of Michigan Head and Spine Institute, PC. The second case law update I have for you focuses on the unpublished per curiam opinion of the Court of Appeals that was issued on July 23, 2025, of Bronson Health Care Group, Inc., and Alfredo Z. Estrada versus Progressive Michigan Insurance Company. This lawsuit relates to an April 17, 2021 motor vehicle accident involving plaintiff Alfredo Z. Estrada. Plaintiff sought PIP benefits under a policy of insurance that Progressive issued to his wife, Esther Estrada. Plaintiff was identified on that policy as a driver and a resident relative only and not a named insured. When Mrs. Estrada applied for this particular policy on or about December 28, 2020, she also elected, in exchange for a lower premium, to exclude PIP medical expenses. Plaintiff ultimately sued Progressive for unlimited lifetime PIP benefits despite there being a PIP medical exclusion in the policy. Bronson Healthcare filed its own provider suit seeking payment from Progressive for services it provided to Mr. Estrada. The two suits were later consolidated. Progressive moved for summary disposition based on Mrs. Estrada's PIP opt-out. In response, plaintiff argued that his wife's PIP opt-out did not bind him because he did not endorse the application for insurance. According to plaintiff, because the form did not, quote, provide a way for him to mark that he elects not to maintain coverage, unquote, the election was invalid under the statute. The trial court denied Progressive's motion and granted relief to plaintiff under MCR 2.116I2. Progressive timely moved for reconsideration, which the trial court denied. Progressive then timely applied for leave to appeal to the Court of Appeals. The court denied leave on without prejudice to Progressive, raising the issue for which it sought interlocutory review in an appeal by right. After additional briefing and a hearing, the trial court entered final judgments in favor of the plaintiff and Bronson Healthcare. Progressive later appealed by right. On appeal, Progressive argued that the trial court erred by finding that plaintiff's wife could not waive plaintiff's PIP medical benefits coverage without his consent, because MCL 500.3107D only required that the wife, as the applicant or named insured, decline coverage, and the Court of Appeals agreed with that argument. In order for an insured applicant to opt out of PIP medical coverage pursuant to MCL 500.3107D, the requirements are 1. The automobile insurance policy must have been issued or renewed after July 1st, 2020. 2. The applicant or named insured must be a qualified person, meaning they have qualified health coverage. 3. The spouse or resident relative of the applicant or named insured must have qualified health coverage. 4. The applicant or named insured must elect to not maintain PIP benefits, and that election must be made in an approved form. And 5. The applicant or named insured must provide the insurer evidence of qualified health coverage for all persons. The court indicated that although plaintiff met the definition of a qualified person under MCL 500.3107D subsection 7C, this is not dispositive. Plaintiff's wife was an applicant and named insured on the policy with Progressive and had qualified health coverage. Thus, she was a qualified person under MCL 500.3107 subsection D7C, and the form had to provide her with a way to opt out of PIP coverage, which it did. MCL 500.3107D5 expressly provides that plaintiff's wife's election applied to plaintiff as her spouse. Requiring Progressive to also provide plaintiff with a way to opt out of PIP coverage would essentially render MCL 500.3107 subsection D5 meaningless per the Court of Appeals. Because plaintiff's wife validly opted out of PIP coverage on behalf of herself and plaintiff, the court found that the trial court erred by denying Progressive summary disposition and granting summary disposition to plaintiffs and monetary awards. The court ultimately reversed the orders denying plaintiff's motion for summary disposition and granting plaintiff's summary disposition, vacated the trial court's monetary awards to plaintiff, and remanded to the trial court to enter an order granting summary disposition as to Progressive. Notably in this case, our firm of Secrest Wardle represented Progressive, and as an update, plaintiffs have not filed a motion for reconsideration to date, but it is unknown as to whether an application for leave to file to the Michigan Supreme Court will be filed. Progressive has also made a formal request to have this case published that remains pending. Finally, I want to discuss the trending topic in PIP litigation of the notice requirement of injuries and MCL 500.3145. First of all, MCL 500.3145, known in the no-fault world as the prior one-year back rule amendment, particularly subsections 1 and 4 states, 1. An action for recovery of personal protection insurance benefits payable under this chapter for an accidental bodily injury may not be commenced later than 1 year after the date of the accident that caused the injury unless written notice of injury as provided in subsection 4 has been given to the insurer within 1 year after the accident, or unless the insurer has previously made a payment of personal protection insurance benefits for the injury. Subsection 4 states, the notice of injury required by subsection 1 may be given to the insurer or any of its authorized agents by a person claiming to be entitled to benefits for the injury or by someone in the person's behalf. The notice must give the name and address of the claimant and indicate in ordinary language the name of the person injured and the time, place, and nature of the person's injury. I wanted to next bring up the case of Hoover Physical Therapy LLC and Medical Direct Transportation LLC versus Amerisure Insurance Company and Berry 365 Day Transport LLC et al., which is an unpublished opinion per curiam of the Court of Appeals that was issued on July 22, 2025. This case has actually brought up 2 appellate opinions lately, and both focus on the notice requirements. In this case, the underlying claimants were involved in a hit-and-run accident on December 20, 2021. The vehicle that the injured parties were passengers in was insured by Amerisure. Here, plaintiff providers sought PIP benefits for services provided to the underlying claimants. Amerisure successfully sought summary disposition based on the statute of limitations. The first applicable unpublished opinion per curiam I wanted to discuss relates to one of the underlying claimant passengers, Antoine Quinney. Plaintiffs contend MCL 500.3145 was told because Amerisure had been notified of the underlying claimant's injury within 1 year under MCL 500.3145 subsection 4 by the insured's telephone calls with the claims adjuster and the police traffic crash report in the carrier's possession. As a reminder, under MCL 500.3145 subsection 4, the required notice must be given to the insurer by either the injured person or by someone in his or her behalf. Reviewing the case of Dragan Perkovic versus Zurich American Insurance Company, the Court of Appeals understood the statute to mean that any person can provide notice of an injury to an insurer on behalf of an injured person if the reason for doing so is some interest of the injured person. This approach comports with the facts in Perkovic because when the hospital in that case sent the bills and records to the insurer seeking payment, it implicitly acted in the truck driver's financial interest of having his medical expenses paid. That is, the relevant distinction is whether the notice was given to the insurer by someone in the person's behalf, rather than merely independently acquired by the insurer. Here, the court found the record did not show that anyone involved in giving the police report to Amerisure was motivated by the underlying claimant, Mr. Quinney's interest. Mr. Quinney's representative called Amerisure's claims representative twice in the course of reporting the accident, but did not tell Amerisure anything about Mr. Quinney's being injured. Rather, the representative initially told Amerisure's representative that no injuries were reported, and in a later call discussed that there were passengers in the vehicle, but did not report any injury to them. The police and LexisNexis, who respectively wrote and transmitted the police report to Amerisure, were not acting in Mr. Quinney's behalf, but rather acting as neutral third parties. Lastly, the adjuster did not retrieve the police report on Mr. Quinney's behalf, but instead to fill out the file for the insured's claim and had no knowledge of Mr. Quinney's potential injury before doing so. The court ultimately held that no one acting in Mr. Quinney's behalf notified Amerisure of his injury within 1 year of the accident required by MCL 500.3145 and affirmed the trial court's ruling. The second underlying claimant of which a recent per curiam decision was made by the Court of Appeals was as to Julian Tancock. Here, the court found that plaintiff provider's claims against Amerisure as to Mr. Tancock were not brought until November 16, 2023, nearly 2 years after the accident that took place on December 20th, 2021. As such, plaintiff's claims were barred by the statute of limitations unless one of the two statutory exceptions applied, which the court found they did not. In this case, the parties do not dispute that the police traffic crash report contained Mr. Tancock's name, address, and the time and place of the accident. Because this appeal can be resolved by addressing the substance of the notice, whether the police report sufficiently described the nature of Mr. Tancock's alleged injury, the court did not need to address the parties' arguments about the sufficiency of the method of notice. The court found that Amerisure had no indication that Mr. Tancock was injured in the accident until plaintiffs filed their third amended complaint on November 16, 2023, nearly 11 months after the statutory limitations period had lapsed. Because the notice of injury exception did not apply, the court found that plaintiffs' claims were barred by the statute of limitations in MCL 500.3145 subsection 1. The trial court's ruling was affirmed. That concludes the August 2025 edition of My PIP Monthly. If you have any questions, comments, and/or concerns, please feel free to reach out to myself, Caitlin Milroy, or Mark Masters directly through the contact info in the corresponding slide. Thank you all for tuning in. Be sure to tune in next month for the latest case law update and trending topics in the PIP world. Take care, everyone.